All rise. All persons having business before the Honorable Company of Judges, now presiding of the District of Columbia Court of Appeal, draw near and give your attention. God save the United States and His honorable court. This honorable court now in session. Please be seated and come to order.
Good afternoon, everybody. Welcome to the District of Columbia Court of Appeals. We have one matter on the calendar today, and that's In re Jeffrey Clark, number 22 BG 891. We will hear first from counsel for the respondent, Mr. McDougall.
With the court's permission, I'll be arguing today, Charles. Petition.
Oh, very good. Mr. Burnham.
Thank you. May it please the court, Charles Burnham on behalf of petitioner Jeffrey Clark. And with the court's permission, can I reserve 5 minutes for rebuttal time?
Yes.
Thank you, Your Honor. The question before the court this afternoon is, does the Office of Disciplinary Counsel's subpoena violate Mr. Clark's Fifth Amendment rights in the face of his valid assertion of those rights in response to the subpoena? And before I go straight to the analysis of that question, with the court's permission, I'll make two preliminary points that sort of position the Fifth Amendment question in the proper context of the larger case. And it won't take long. The first point is our position throughout these proceedings, including before the hearing committee, is that this court and the hearing committee lacks jurisdiction, which is logically precedes the Fifth Amendment and other issues. Our position is jurisdiction can be raised at any time. We're raising it now. And our position is the court has a responsibility to satisfy itself of its own jurisdiction before deciding any other issue, including the one before the panel today. And I'm happy to answer any questions about that. I'm sure the court have any. Secondly, and even more briefly, some of the briefing leading.
Could I just pause for a second?
Sure.
That argument was raised and rejected in the DDC, right?
It's a different argument. That was our removal argument, which is something we did raise, and that was rejected. It's on appeal to the federal court.
So could you articulate for me what your argument is on jurisdiction? Because this has not been briefed at all. I appreciate you we have to satisfy ourselves, and it's the kind of thing that you can raise late, but just articulate what the argument is.
Sure, Your Honor. And actually, we did raise this in response to the investigative stage subpoena that was filed before the specification of charges, and then incorporated that filing into our response to the current subpoena. So technically, it has been briefed.
Technically, it has not been briefed before the court. We don't accept incorporations into briefs. So if you try to incorporate everything we've said before, that doesn't work.
I understand.
But I do appreciate that jurisdiction is something that we need to satisfy ourselves of. So what's the argument? And if you think it's somewhere in the filings before us, point me to where so that we can take a look at it too.
It would be in the incorporation issue that Your Honor raised is something.
I'm sorry. If I'm going back into all the document, the entire record, is there a citation you can give me, a page number to a record before us that I would look to?
I don't know the page number, but I'm sure my co-counsel can find it and I can provide it to the court.
Okay.
It is our response to the initial subpoena.
Sure.
But I can summarize it easily. There's a federal statute, 28 USC 530B, that grants to the states, using the term the states, authority to impose bar discipline on federal lawyers acting within the courts of their duties. Our argument is very simply that there's a time-tested, well-recognized way for our United States Congress to treat the District of Columbia as a state. There's language that's commonly employed to do that. Congress specifically declined to employ that language here in 530B. And so for that reason, the authority to exercise bar discipline against federal lawyers like Mr. Clark was for actions in the course of their duties is not within the disciplinary jurisdiction of this court, of the hearing committee, and the board, and so on. In our position.
So that was addressed by the DDC there, wasn't it? That was page 3 of the decision dealing with the McDade Amendment, right?
It absolutely was, Your Honor, yes.
And so what's wrong with the way they addressed it? I mean, that McDade Amendment, if I'm remembering correctly, specifically referenced the District of Columbia and putting that language into the statute.
Your Honor, our position on that is that under standard principles of statutory interpretation, where the language of a statute is clear, as we submit that it is in this case, recourse to legislative history is not warranted. And so with all respect to Judge Contreras, we would contend that that long discussion that he did engage in about the McDade Amendment and different statements by different legislatures was not called for or even appropriate where the text of the statute is clear as to what the grant of authority is or what it's not.
And I just wonder, what's the status of that in the DC circuit? You've appealed that decision from Judge Contreras. It's in the DC circuit. Has it been scheduled?
We'll be completing our reply brief by March 7th, and then it will be fully briefed at that point.
Got it. Okay.
We, of course, did seek to persuade the hearing committee to defer the case for many reasons, the criminal case in Georgia, but also the removal proceedings, and the hearing committee didn't agree with our request to do that. So that case is going forward, perhaps before the DC Circuit acts, we're not sure.
Okay. Maybe we can move you on to the Fifth Amendment argument.
Certainly, just 10 seconds for one other point, and then I'll
Sure.
go straight into it. A related point is I just wanted to remark that there was some briefing in this very matter about executive privilege. Our position is that's not technically before the court now, before the Fifth Amendment issue is resolved, but it's waiting in the wings and may turn into an issue at a later point. So with
With
that,
regard to that,
Mhm.
just to clarify this, are there potentially responsive documents that as to which Mr. Clark is claiming executive privilege or any other privilege that is not the Fifth Amendment privilege? In other words, are there documents here, are all the documents at issue documents that Mr. Clark is claiming a Fifth Amendment privilege to? Or are there some that he's not asserting the Fifth Amendment privilege to, but is asserting, for example, executive privilege?
all unproduced documents, to the extent any exist, are subject to our Fifth Amendment assertion. And I'm in a bit of an awkward position because under the law, I can't very well talk about whether there are documents, the nature
I
of them, how
understand.
many.
I understand that. And we're not going to treat you as having admitted the existence of anything
I understand, Your Honor.
in that sense. The reason I asked that question is because it may be the case that Mr. Clark does not have to prepare a privilege log in connection with Fifth Amendment related documents. But I think he would have to prepare a privilege log if there were documents as to which he's claiming only executive privilege, for example. And that affects the scope of an order that this court might ultimately issue.
I agree with that.
Okay.
So I'll move straight then to the Fifth Amendment analysis, and I'll start for reasons that will become readily apparent, hopefully, with the underlying purpose of the Fifth Amendment, I think, is implicated very directly here. And what is that? Why do we have a Fifth Amendment? Why did the framers draft it the way they did? And the purpose of it is, and this comes straight from Doe 2 and other Supreme Court cases, was to prevent an inquisitorial system of justice such as existed in some parts of Europe from ever developing in this country. In this country, we have an accusatorial system. And so why is that important for this case? I would submit that if we look on its face at Office of Disciplinary Counsel's subpoena and the way it's drafted, it's highly inquisitorial in its language. It demands to know on pain of legal sanction from a current criminal defendant allegations about that go directly to the criminal case, what he researched, what he knew, what his contention is to support certain claims, what laws he may or may not have been aware of. And that's the way we presented our brief the way we did. We don't necessarily have to, I would respectfully submit, delve into the technicalities of active production.
Let me ask you a question. With regard to this subpoena, it's my understanding, correct me if I'm wrong, that Mr. Clark has produced documents, some 4,000 pages of documents that are said to be responsive to the requests of the subpoena and as to which he is not claiming a privilege. So that tells me that merely because a document falls within one of the categories in the subpoena by its description, that doesn't necessarily mean it's privileged under the Fifth Amendment. How do we draw that line? Does the fact that there's been a partial production, a substantial partial production, have a bearing on the claim of privilege as to other documents that also fall within that subpoena? Is it a waiver? Is there some standard by which that's being applied here that we need to know about? You see what I'm asking?
I do, Your Honor, and we don't believe it does constitute a waiver for several reasons. The first is there's no case, and we did look, treating a active production, partial production, so to speak, in the same waiver terms that say partial testimony would be treated. You can't get on the stand and pick and choose your Fifth Amendment questions. There's no comparable cases for active production that we could find, or indeed that ODC at least has cited. And there's very good reasons why there wouldn't be such cases. It would not be, I would submit, irrational in terms of judicial efficiency to require the Fifth Amendment active production to be an all or nothing situation.
I'm
That's the
with
first
you
one.
on that, but then the question becomes, how do we know that the Fifth Amendment privilege is not being asserted too broadly with respect to the remaining documents?
Under this court's precedents, including United States versus Wilson and others, the method to assess that is to look really at three things. One is the totality of the circumstances, which would include the related criminal cases. Two would be the nature of the information sought. And three would be the purpose for which the information is sought. That's the way the courts have approached that, to determine if there's really a valid Fifth Amendment assertion and not something ephemeral. And so let's apply those three factors to this case. First, the facts and circumstances include: one, a pending criminal case for racketeering in state court, that if the indictment involves several overt acts in the RICO count that overlap almost exactly with the specification of charges here and the subpoena. That's one. Another relevant fact and circumstance is a criminal case against a former president in our district court, where Mr. Clark is named as an unindicted co-conspirator. There again, the factual information in the indictment overlaps almost exactly, even more so than Georgia, frankly, with the specification of charges here and the subpoena. So those are very important facts and circumstances that I think dramatically implicate the Fifth Amendment, far and away beyond even any case we've seen cited. So that's the first. The second is the nature of the information sought is information that bears directly on the allegations in a pending indictment. And finally, the purpose for which the information is sought is to prove the very same allegations, for the most part, that Mr. Clark is currently in criminal jeopardy for. So we submit that all those three factors weigh conclusively in our favor. And I'll just add one.
I mean, those factors might weigh in your favor. But imagine the subpoena were more targeted.
Mhm.
Imagine that it was, disciplinary counsel, based on your client's own statements, was aware of a December 15th email, I'm just making this up, between Mr. Clark and Mr. Wall. I think they could undoubtedly subpoena that, say, produce that email, right? Even though there would be, all three of the factors you just listed would still be present. There'd be a pending criminal case, it would be relevant to that criminal case. But I don't think you'd have any argument after Fisher that you would have to turn that over, right?
Absolutely. And Your Honor, I think, is alluding to the foregone conclusion doctrine.
I think that's right. I was trying to draw you there. What about, there are aspects of the subpoena that I tend to agree with you is where they're really trying to mine your client's mindset, particularly at a past point in time. But there are aspects of it, I mean, maybe limited aspects, but what about the produce all written policies and guidelines of the DOJ? The last paragraph, why isn't that particular enough? Those policies exist. The question is, and if you've got them, hand them over. What's the problem with that?
Because the government has a particular burden to satisfy the foregone conclusion doctrine, meaning they would have to prove at least four things. One is the existence of the documents. Two is their compliance with the term, or matching the terms of the subpoena. Three is the custody and control of the documents by Mr. Clark. And fourth is authentication. And that's in any active production case. And here we would add the testimonial assertions that, as Your Honor just alluded to, are inherent in the way the questions are drafted, including the one Your Honor just mentioned, that I think the way it's phrased is that Mr. Clark was aware of. So he'd be adding a fifth testimonial statement.
What if we cross that part out? And then this kind of goes to the entire subpoena. What would your response be? I take your point when it says of which you were aware in the subpoena. There's a troubling aspect of the subpoena. It really seems to be calling for something testimonial by way of production. What if it was just produce all written policies and guidelines of the DOJ that existed prior to or in this window, November to January 4th, 2021, that are in your possession? That would not seem to require any sort of active production testimony, would it?
I disagree, Your Honor. The
Why is
fact of custody and control is sufficient by itself to defeat a foregone conclusion argument, which is, again, what they're not even making that argument. That's one problem. It's not before the court.
If you don't think it's a foregone conclusion that a former AAG would have possession of policies and guidelines of the Department of Justice regarding contact with White House officials?
No, Your Honor. In fact, that very argument has been made in one of the cases cited, and that the IRS argued it's a foregone conclusion that so-and-so has some kind of tax documents, because everybody pays taxes. We know that. That's not sufficient. They have to have knowledge that Mr. Clark,
Yeah, I think you're talking about Hubble, right?
that maybe.
Was that Hubble? This is not, it's not really like that. This is not, every business has business documents and give us all your business documents.
Mhm.
This is a 1 month window of time, DOJ policies and guidelines. That's pretty specific. I think the DC Circuit has kind of interpreted this triumvirate of cases from Fisher to Hubble to Doe to mean, the subpoena needs to be drawn with reasonable particularity. And not a certainty that this person has these exact documents. You don't need to identify the specific documents, but kind of a narrow class of documents is my rough takeaway from what Pons said. So that seems pretty narrow to me. Why is that? Why do you take issue with that part of the subpoena?
Because producing such documents as your Ozer posited would still have inherent in it several testimonial statements. We'd still be admitting that whatever the policies are, and we're not sure of the universe of policies, potentially there could be policies that may or may not be included. We'd be admitting that whatever policies we may or may not be able to produce match the description in the subpoena. That's one. Two, we'd be admitting custody control, which we could argue about exactly how much incriminating air quotes value that might have, but it's unmistakably a testimonial statement. I have these documents. In fact,
That's always true. That's true of everything in Fisher though, too. You're always admitting I have these documents and the Supreme Court says, well, if having the documents is not particularly incriminating, and here having DOJ policies and guidelines I don't see how that would be incriminating of your client any more than the tax documents in Fisher that could be subpoenaed. So it seems like your argument's sweeping quite broadly in a way that's inconsistent in my mind to Fisher.
Well, in Fisher, I think the government had independent knowledge that the documents were in possession of the subpoena targets. We know this. We know we have them. There's no protection in the contents, so we just need to get the contents. Here, there's no proof or argument that the ODC has offered that the policies are in Mr. Clark's possession. And you could easily conceive of an argument saying you took those with you from your job. Why? Does that connect you to something that some prosecutor is alleging you were involved in? There is probative value there, we would submit respectfully.
Does your position end up in effect meaning that a person who receives a subpoena like this can produce all the documents in that person's possession that are helpful to the defense, that are exculpatory, if you want to call it that, but withhold all the documents that are harmful to the defense, even though they all, in a sense, answer questions about or might be used to answer questions about the individual's awareness, knowledge at the time of the events in question. That's what it comes down to, right? Mr. Clark, for example, can weed through his documents, whatever that, I'm not saying he has any, but whatever he has, and say, well, these are helpful to me. I'll give those to disciplinary counsel. And these are not helpful to me. I'll hold those off and I'll invoke the privilege against self-incrimination. Now, it's funny, and if a lawyer in a courtroom proceeding were doing something like that outside the Fifth Amendment arena, we would say, well, that's very dishonest. You're not supposed to respond to that. That's like an ethical violation in and of itself. But that seems to be your position with regard to the Fifth Amendment. Do I have that right?
Theoretically, there's no case that precludes that I've seen, but I wouldn't by no means admit that that's the way we're proceeding.
Well, I'm wondering
here.
what constitutes a waiver in this case. That's really what my question comes down to.
I don't think there is a waiver in this case, I would by no means concede that the production we did make necessarily involves protected documents. When you're in a disputed situation with opposing counsel, sometimes you look and say, well, is there kind of sort of an okay argument maybe ODC could make that maybe we don't agree with, but we can kind of see what they're saying. We can produce pursuant to that. Now, I'm not obligated here to explain our whole thought process, but that's something that a subpoena target could very reasonably do. And the one example I think that's already in the public domain, so I don't feel myself prohibited to, and I'm sorry, I see my time has expired.
That's
I assume I
okay.
can continue. That's already in the public domain, so I'm a little bit more at liberty to discuss it, is one of the documents that ODC received was something that the special counsel obtained pursuant to a search warrant, and it became known, in the public domain through the news and so forth. And so there was maybe not a conclusive, but an okay foregone conclusion argument. And so without waiving our privilege, I submit, we could say, okay, we'll go ahead and produce that one in an effort to meet counsel halfway. I also think there's much less potential for abuse of such latitude than perhaps the court may be supposing, and that there's much less gamesmanship inherent in being able to produce some documents and not other, as long as you're upfront about what you're doing, saying we're producing some, but we're not representing that this is complete. And then the Fifth Amendment act of production can be litigated as we're doing, and that's something that happens all the time. And whatever the investigating authority is, be it a prosecutor or ODC or whoever else, can at least get some evidence, which I think would be a salutary result for the law to arrive.
What makes it harder is the absence of a privilege log in which there's a listing of document by document.
That does make it harder, but I think Your Honor, even the way I interpret it, understands that under the logic of the act of production privilege, we can't. And there's even a case that if I had had a reply, I would have put it in my reply brief, SEC against Coldicott, 2017 Westlaw 2485383, where the respondent tried to do like a mini privilege log that had just barely enough information. And that was held to be a waiver of the act of production. So our hands are really tied. Maybe it would be nice if we could produce a log, but we can't.
If the hearing goes forward and Mr. Clark chooses to testify at the hearing, can he utilize documents in his defense? Or even if he doesn't choose to testify, I suppose, can he utilize documents in his defense that as to which he has claimed the privilege?
Well, I
In
would
pre-trial-
expect.
In pre-hearing discovery?
I have to think about that for a second. I think that would be a question that would have to be litigated at the time. That's not anything I could represent as our plan. ODC may have, I don't know the answer to that. Perhaps I'll think about it and respond in my reply sign. That's not our plan, Your Honor. Yeah. Can I, actually, before I sit down, can I just answer directly, Judge Deal, Your Honor's question? The response to the original motion to compel and cross motion to appeal filed by respondent Jeff Clark on February 15th of 2022 on page 14 through 19 sets forth, that's in this court's filing, our 28 USC 530B jurisdictional argument.
Very good. Thank you, Mr. Burnham. I know you reserved 5 minutes and we took you over your time. We'll be sure to give you your 5 minutes on rebuttal.
I appreciate it. Thank you, Your Honor.
All right, Mr. Fox.
Thank you. May it please the court. Let me say at the outset, at this point, this subpoena has been outstanding since October of 2022. Our primary concern is with the first category of documents that are in the subpoena, which says they're documents of which you are aware before January 4, 2021, that contain evidence of irregularities in the 2020 presidential election and that may have affected the outcome in Georgia and other states. That's the primary concern that we have.
And can I-
So
Oh, please, Judge Howard.
I was going to say, so with that primary concern, you've got at least 2 criminal cases that are addressing those same facts now. What is the harm in waiting for that to resolve and letting that litigate out and then bringing in the evidence that should be abundantly available to you?
Well, one criminal case, Mr. Clark is not charged in, the one here. The second criminal case, I have no faith in whatsoever. Both in the, for a number of reasons. And this investigation began before those matters existed. The 3 elements of the act of production. One is not contested. We're trying to compel the production of these documents. The second element is whether the documents are testimonial. And I'll come back to that. But the third element is whether they're incriminating. And we have not asked for in referring specifically to the category I just talked about, we haven't asked for incriminating documents. We've asked for exculpatory
Well,
documents.
it might be a little bit too cute. When you say, give us everything that supported your claims that there were irregularities in the Georgia election, by producing the universe of those documents, that could be extremely incriminating. Because what you've done is you said, this is all I had. What if there's nothing? I know that's not the case here, but let's say you issued this subpoena to somebody and they said, give us everything you've got that supported the claims you've made. And they try to comply with the subpoena and say, you know, we are complying with the subpoena, but we've got nothing. They've just hung themselves.
Well,
Admitting to a limited universe of support is just necessarily going to be, I mean, it's at least potentially quite incriminating.
it is, do I understand what you're saying is that if there were no responsive documents, that would be incriminating? That would be sort of the act of non-production.
Or 5 responsive documents that came from theonion.com.
Right.
Or, you know, or just the most frivolous of support would be incriminating.
So let me go back to maybe the testimonial aspect, which I was going to refer to. Arla. Remember, this entire case is built around a letter that Mr. Clark wanted the Department of Justice to send. And that I have this letter right here. This is what he wanted the department to say. No doubt many of Georgia's state legislators are aware of irregularities sworn to by a variety of witnesses, and we have taken notice of their complaints. And then he says, C, for example, and he references 2 documents. One is I guess you would call it a legislative report from Georgia. The other is a newspaper article. That's an admission, it seems to me, that there are additional documents that support the statement that he made, that there's irregularities in the Georgia election. That's what we're trying to get. So we're not in a situation where there are no additional documents. We're looking for those documents. Now, he's produced those documents. But he hasn't produced the others. And that's what we want him to produce.
When you say what's in the 4,000 pages of documents that have been produced so far?
Well,
I just haven't flipped through them. I probably should, but
I have a lot of, most of them are completely irrelevant. I think it looks like it's a back up the truck kind of production. I wonder why, if they weren't governed by the active production doctrine, they weren't produced months and months and months ago. Because I don't know, Judge Glickman's point a moment ago, I don't know what the line is that they're drawing here between what they're producing and what they haven't produced. I don't see how a lot of these are irrelevant or relevant. I don't see how a lot of them have anything to do with self-incrimination. But if they don't, they should have been produced months ago.
But the thing about the request that gets to me is if you were trying to comply and if Mr. Clark had handed over literally everything that he had, just assume he did. If I were his defense counsel, there's no way I would say and tell them, and that's all I have. That's everything that you were aware of, because that's very incriminating. You've just given incriminating evidence against yourself by saying you had nothing more than that. So you can ask for documents. You know, Fisher says you can subpoena specific documents that you want, but it's the little additional part of, and this is all I knew about, which is what you're asking for in the subpoena. This was all I knew about when I read that letter. That sounds to me, unquestionably testimonial. Well, you're not going to find that from the documents themselves, right? That's not something that this is all I knew about is both the potentially most damning thing he could say, and it's not coming off the face of the documents at all.
Well, I'm not sure about that. I mean, let's. I think you suggested earlier. Let's remove that language for the sake. Let's just say you said in this letter that there are some additional documents that support your claim that there are irregularities in the Georgia. Produce those documents, which is what we're trying to get at here. Produce those documents. If he produced 2 or 3 documents and they were from the Onion or whatever, and that's all there were, Well, that would probably not help his case, but it seems to me that under Fisher, clearly we would be entitled to have those documents.
Yeah, except here's the thing about it, though. It's definitely incriminating under that scenario. And so then we're back in the question of whether or not it's testimonial. And in Fisher, the damaging aspects were the contents of the documents themselves. They were tax papers of some sort. I don't remember exactly. And you could look at those tax papers. They were already prepared. And the content of those tax papers is what was handed over, and that's what was incriminating, and that's what was permitted. But you're not looking for the contents of these documents so much as you're looking for, and this was all I had. And it's that aspect of this subpoena that by complying with the subpoena, they are admitting that they have nothing else. And that's a testimonial aspect of the subpoena.
Well, but isn't that inherent in any subpoena for documents? If for example,
I don't think it is. I think in Fisher, there was a known universe of documents. It was a universe of tax papers that had already been provided to Mr. Fisher's attorney. And part of what the court's reasoning was, and then later they cut back on a little bit in Doe and Hubble, was you already know what those documents are. It's a foregone conclusion that they exist. You know the subset. You might not know how many pages, or you might not know their names, but you're looking for a closed universe, and it's that material that you're looking for the contents of. And here it seems to me you're not really looking for the contents of any material. What you're looking for is how much did you know when you wrote this letter?
well, I guess there are two things I would say about that. The first is that the primary reason we want this is we want to show it to our witnesses, because our witnesses are going to testify that there wasn't any basis for this claim. And I want to be able to show, well, did you consider this? Did you consider that? But I think I think you push too far when you say that. Look, for example, all the time we subpoena from lawyers their financial records when we get an overdraft case. Okay, you all have undoubtedly encountered that. First thing we do is we subpoena the lawyer's financial records. In this jurisdiction, there's no specified list of financial records that lawyers have to keep. Virginia and Maryland do. We don't have that. So we solicit and we try to think of everything we can, the ledgers and the such and so forth. And we ask all that stuff. The lawyer may not have it. Sometimes they don't. We end up charging them with failure to keep adequate records. That is a consequence of our trying to get hold of the records that they do have.
Well,
But-
it may be the case that if the lawyer really had a credible claim of criminal exposure, the lawyer in that case could refuse to respond. I mean, look, suppose you issue an interrogatory to Mr. Clark, which says to Mr. Clark, admit that you were basing your letter to the Georgia legislature on news reports in the Onion. Admit that. Well, Mr. Clark clearly would have a Fifth Amendment privilege to say, no, I'm not going to respond to that. I have and invoke his Fifth Amendment. That's what this subpoena is doing. Now, it doesn't have to be quite so gross as an example of documents that came from the Onion. Whatever Mr. Clark produces, the opposing party can say, well, this is really clearly inadequate. No reasonable lawyer could have believed that this was sufficient. That's an arguable point. And it's the same point that presumably would be being made by the prosecutors, charging him with either in Georgia or charging him as an unindicted co-conspirator. You're getting an admission from him by his response. These are the documents to the question, what documentation were you aware of at that time? And even if you take out the words that you were aware of, just give us all the documents you have. That too, just giving them and admitting that these documents are authentic and that he has them. Where did he get them from? He had them at the time. I mean, the Fifth Amendment privilege is extraordinarily broad. And I do have difficulty seeing how this subpoena can get around that.
Well, make a couple of points. First, I do think this is kind of the active non-production doctrine, and I'm not sure, I'm not aware of the law. But second, this is not an argument that Mr. Clark has made. The court is coming up with what I would say is an imaginative argument, but it's his burden to come forward and demonstrate that the privilege applies. His argument has not been that I don't have any documents, or I might not.
No,
have
he
any
certainly doesn't want to say that, but
or I might not, or whatever.
but his point is, I give you this stuff and you'll argue and you'll try to use it against me.
Well,
Just as
but-
it's not so much that you would, because you're entitled to, but that a prosecutor would.
Yeah, but if we subpoena documents all the time, that
I think that's a problem. It could be a problem in other cases. I agree with you.
let's talk about what the I guess it's Fisher and Hubble really talk about when they talk about the testimonial aspects. And they say, I think, three things, or maybe it's four, that the testimonial aspect when you produce a document is that the document exists. Okay. He said in the letter, CEG, these are examples of documents. So he's already
Got that.
all right. That it's in his possession or control. Okay, we're asking for what the documents he relied on were. That it's authentic. I don't know that that's really a issue here, since we're pretty much looking for, third-party documents, and that there's a belief that these are the documents that the subpoena called for. Okay. I don't see how any of that, when you're asking for documents that support his position, incriminates. And that's what testimonial means, according to the case law. I don't think any of that testimony incriminates him. And what we asked for, and we did this deliberately, we asked for exculpatory documents. We asked for the documents that were the basis that, what were the other documents on which you were relying besides the two that he turned up. And I also am troubled by the.
In a criminal case, do you think that, if this were a criminal case, do you think that the prosecutor could say to Mr. Clark, tell us all the document, give us in advance of trial, all the evidence you have, all the knowledge that you have, that supports your position? I would have thought the defendant in a case like that can say, I'm invoking the Fifth Amendment privilege. I'm not saying anything. And in fact, if I do say things, if I do tell you stuff that supports my position, that may constitute a waiver with respect to information that doesn't support my position, because it's all the same subject matter. Wouldn't that be a problem?
It phrased the way you say it, of course it would be a problem. But if you have a situation where he's represented that there are other documents on which he's relied that presumably are in his possession, and you subpoena those documents, I don't think there's a testimonial aspect to that makes it incriminating. Maybe the problem is with my use of the language, on which you relied, or whatever I said. But subpoenas can be reformed. I'll serve a new subpoena, or the court can reform the subpoena. What I want to see are the documents that support the statement that he says exists. And I want to see them for the reason I told, so I can show my witnesses. And are these things that you considered when you, as the officials of the Department of Justice, took the position that there was no evidence of any election fraud that would have affected the outcome of the election to 2020. And I don't think within the four elements of testimony that the court has set forth in Fisher and in Hubble, that fits in that category. Because of his statement that, this is part of what I've got. So,
Counsel, let me just ask you maybe a couple practical questions.
sure.
Why could you not just ask those same witnesses? Did you see anything that contradicted any documents that contradicted your view that there was no interference there was no chicanery in the election down there? Why would that not be sufficient? Like, why do we need to go to these lengths?
Right. And the reason for that is I have to sort of explain a little bit about the case. The primary witness here was the fellow who was acting as the principal, exactly as the deputy attorney general. It was the end of the administration. Everybody's in acting jobs and so forth. It wasn't his title, but he was in effect the deputy attorney general. And he was in charge nationwide with supervising all of the election fraud investigations that were going on. And he said that there, was no, there just wasn't any evidence that would affect the results of the election. And that's what he told Mr. Clark. Mr. Clark has since given indications that he thinks that person did not do an adequate job, that there was information and evidence that he overlooked. So I want to find out what Mr. Clark is basing his statement on, that there is evidence of election irregularities, and I want to show this witness, Mr. Donahue, did you overlook this?
I get it. And
Yeah.
did you consider it? That's
Right.
That's great. So do you have concerns that somehow by surprise at your hearing, Mr. Clark and his team are going to come up with the evidence that they didn't want to give you before, and now you're going to have some surprise? I know ODC, there's a disciplinary rule that things have to be produced in advance of evidentiary hearings, et cetera. Isn't it more harmful for them to proceed right now without being able to defend themselves because of the fear of incrimination?
Well, it's not clear to me that the rules that say you've got to produce a witness list govern cross-examination materials. I certainly would be objecting if that were the case, but whether or not a hearing committee would say, well, this is cross-examination, they don't have to list in their exhibit list all the documents they're going to be using cross-examination. That's I think that's an iffy kind of thing. I mean, cross-examination, we all know sometimes things come up, the witness says something you don't anticipate. You pull it, but you've got a document somewhere that would refute them. You pull that document out, and it may not be on your witness list. So, while I think it would be dirty pool, I would like to safeguard against that.
Do you know, I asked a little bit of this of Mr. Burnham. Is that DC Circuit case? And I don't think there's I can't think of any reason why we would trail that case other than there being perhaps similar jurisdictional questions. But is that expedited? Is that going to be a March hearing decision kind of thing, or is that?
We don't have a hearing date yet.
Okay.
They have denied twice now, I think, efforts to stay the case. The DC Circuit has denied efforts to stay the case.
Okay.
But I don't know if it's expedited. They have, our sort of unofficial view is that the court seems to be proceeding rather quickly with these sorts of cases. But that's just, that's me reading the tea leaves. That's not anything official.
And my other question was, if I'm right, the hearing is scheduled to begin around March 26th or 7th?
26th. Right.
26th. And while I can assure you that we're treating this with speed, I expect you'll get an answer from us soon. Is there sort of a date at which this becomes, the hearing just gets pushed back if you haven't?
Believe me, I'm not going to push that hearing back unless somebody cuts off one of my arms. But
I don't think you need to give us a deadline, but I'm just curious if there is some deadline that is in your mind that sort of, if it's going to be trouble if we don't have this resolved by.
No, I told you the reason way I want to use it. I want to show it to the witnesses. So I need to do it in time. I'm assuming it's not going to be voluminous and that I can make it available to the witnesses. We've already given them the stuff that has been produced that we think is relevant, which not much, but principally this report from Georgia, which is specifically mentioned in the letter that underlies this whole case, and which they have produced. We've turned that over. there are no additional questions.
Well, I guess I should raise one other matter with you, and that's the jurisdictional matter that council raised earlier. We do, as you know, my colleague said, we do have to um uh, b- b- be fairly assured of our jurisdiction
Yeah.
to proceed, and he's raised that issue. Do you want to comment on that?
Well, I really rather rely on Judge Contreras, but I guess the main point that I would make is that, and I got the statute, that's what I pulled up here. It's 28 USC 530B, the so-called McDade Act. In addition to the McDade Act, and this wasn't mentioned before, there are interpreting regulations by the Department of Justice itself. And the Department of Justice itself concedes or has regulations that says this applies to the District of Columbia. And as some of you, maybe all of you know, we have brought cases in the past against Department of Justice lawyers for violating your rules of professional conduct.
I'm well aware of that. I just wonder whether it can be argued that whatever the jurisdiction of this court is or is not, a regulation of the Attorney General is not sufficient to change it.
Well, it can be argued that, I mean, Judge Contreras, I think, goes into this at great length and explains why that argument wouldn't make much sense in the context of the way this law came about. I mean, the Department of Justice lawyers, I don't have a number for you, but I promise you that more of them practice in the District of Columbia than in any other jurisdiction, maybe in the federal courts, but they practice here. The notion that somehow or other you would say that all the Justice Department lawyers are subject to the rules of professional conduct of the states in which they're licensed, except the District of Columbia, the state in which where most of them, practice is pretty bizarre. Plus, in Judge Contreras' opinion, he points out that at the time this law was enacted, the main concern was an independent counsel investigation that was going on in the District of Columbia and whether or not the lawyers who were conducting that investigation were complying with the rules of professional conduct. So the notion that you would enact a statute and exclude the District of Columbia in that context of the way the statute was enacted would be truly bizarre. And the department itself, I mean, I don't know if, the department itself interpreting and applying the regulations, the agency that has to administer them, interpreted as applying to the department, to Justice Department lawyers in DC.
Thank you, Mr. Fox.
Thank you.
And Mr. Burnham, you can have your 5 minutes for rebuttal.
Thank you, Your Honor. I'm happy to take direction from the court, but I have a few points. One is just in passing, we mentioned it, executive privilege earlier. I'll just note in passing that counsel for the privilege holder has joined us in court today. He's not a party, but he has an interest in the case. That's Mr. Blanche of New York. One thing I failed to mention in my initial argument is that the case that actually holds conclusively that the Fifth Amendment applies in bar discipline proceeding that's mentioned prominently in our briefs is In re Artis, of course. There's another aspect to that case that I should have mentioned, that one of the reasons that came out the way it did really had nothing to do with the Fifth Amendment. One of the holdings was the inquiries there were described as interrogatory-like questions, which apart from the Fifth Amendment simply just weren't authorized for, back then it was bar counsel. We would submit that these questions here could very accurately be described as interrogatory-like questions as well, asking for documents in addition, though they certainly do. And so that's a way this case could be resolved without even reaching the Fifth Amendment question. I understand we're here to talk about the Fifth Amendment, but that was in the briefs. I want to answer your Honor's question directly about, could this be gamesmanship if we decide to, take out the documents later? And I think there's two aspects to that. It depends on how it would play out procedurally. Mr. Hirsch has provided a discovery schedule, where both sides have to exchange their exhibits, ahead of time and so on.
And 10 days before
It's actually even more than that.
maybe it's more than that.
And so there was some unfair prejudice to ODC. They could certainly argue that. I also think if Mr. Fox alluded to, if one of the documents was used in cross-examination, let's say, I perhaps wouldn't have a duty to say where I got it if it could have been responsive to the subpoena, but that's going to be true in every case where the defendant might have Fifth Amendment material to use in cross-examination. It's just not an issue before the court where it came from. But I don't think that's in any way aggravated by applying the active production doctrine. That's just.
Mr. Fox makes the argument that when they're only asking for documents that are, I'll use the word exculpatory,
Mhm.
that the active production concerns don't really apply to that. And that you can be required to produce that, even if producing it is an admission of the authenticity of the document, or I had it at the time, or what have you.
There's two responses to that. One is solicitous of, as that objective of theirs may be, we're perfectly capable of gathering our exculpatory evidence without their help. But more seriously, I think with all due respect, Office of Disciplinary Counsel isn't quite grasping the Lincoln the Tame doctrine, articulated most famously from Ohio versus Reiner, but it comes up all the time, which that states with the documents don't have to be in and of themselves incriminating in the colloquial sense or illegal. They just have to help the hypothetical prosecutor complete one link in the chain. And what would be some of the links in the chain, just to make it concrete in a hypothetical criminal prosecution of Mr. Clark? They would be that Mr. Clark was a lawyer. He was in the Trump administration. He had certain jobs. He attended certain meetings. He researched such certain issues, and on and on and on. All of those are links in the chain in a hypothetical prosecution. None of them are inherently illegal themselves, all of which would be protected by the Fifth Amendment, and all of which are manifestly implicated by the subpoena here. And I would also add.
Well, focus just on, I mean, Mr. Fox made clear that his primary concern is the first subpoena category.
Mhm.
Documents of which Mr. Clark was aware
Mhm.
in the relevant timeframe, that contain evidence of irregularities in the 2020 presidential election and that may have affected the Georgia outcome.
Mhm.
Now, every one of those documents presumably helps Mr. Clark's, if they exist, presumably helps Mr. Clark's case. They're not incriminating.
I would disagree for two reasons.
That's
one
what
of
you've got to argue.
One of which was aptly illustrated by Judge Deal's hypotheticals, none of which I would admit, but theoretically, we've got nothing. We're making it up. That would be a very damaging admission. Secondly, the Fifth Amendment doesn't presuppose a reasonable and ethical prosecutor. If anything, it's the opposite. It presupposes a tyrannical prosecutor. That comes straight from United States against Quinn. In other cases, the same. And in a lot of these 2020 election cases, the dispute comes down to what's illegal and what's aggressive or creative lawyering. So evidence we may feel, to the extent it exists, is highly exculpatory. Mr. Fox or another prosecutor may look at it and say, no, we think this is inculpatory and we're going to use it in our case. Those differences of opinion are still well within the ambit of the Fifth Amendment. A couple practical points that I think came out is, one is there was an admission from ODC that they don't really need these documents. They're planning to go forward with the hearing either way. That was their position back when the hearing was originally
I wouldn't
scheduled.
characterize it that way, but okay. I mean, they'll go forward, might go forward with
Right.
a worst case.
They're not going to wait on a ruling from this court or wait on that. They're ready to go forward in January. So I think that's proof. They made no efforts to get the documents from the Department of Justice, that we know of anyway, that conceivably they could have. And then I want to also answer the question that came up with jurisdiction about the regulations. Is I think the answer to the questions the court gave are absolutely right. I would just add that under the Chevron doctrine explicitly, since we would argue 530B is clear, there's no authority for the Attorney General to place an interpretation on that statute that contradicts the text. That's why we feel that regulation doesn't control, nor does the cases from this court, disciplinary cases against lying U.S. attorneys for lying to the court or not producing Brady or something. In none of those cases that we've seen or that ODC has cited to was this jurisdictional argument made. The phrase for that I've heard is drive-by jurisdiction, where the court exercises jurisdiction without considering a particular argument, which is not precedential for the argument we're making.
Thank you, Mr. Burnham.
Thank you, Your Honor.
Thank you, parties. We appreciate your briefs and arguments. The case will be submitted and the court is adjourned.
Honorable court is now adjourned.